Hi, I'm Dave Taylor, tech blogger at AskDaveTaylor.com, and I'll be facilitating today's discussion between Ann P. Mitchell, attorney at law, and Michael Ashton, senior director of platform at Liquid Web, on the topic of General Data Protection Regulations, or GDPR. Let's start with some introductions. Ann Mitchell is an internet law and policy attorney with an emphasis in email law, policy, and compliance, and GDPR compliance. She is also the CEO of the Institute for Internet Public Policy, which provides the SuretyMail email reputation certification service. Michael Ashton is the Senior Director of Platform at Liquid Web and is responsible for, among other things, compliance and data center network operations. Prior to joining Liquid Web, he was the Chief Information Officer for Ingham County, Michigan, and has over 20 years' experience in government IT. So, let's go ahead and jump in. And maybe, Ann, can you start? What is GDPR and when does it go into effect?
Sure, Dave. Thank you. GDPR, which, as you said, stands for the General Data Protection Regulation, is a regulation, and now in just a few days, on May 25th, will be a law. That's when it goes into effect, which was passed in the EU, the European Union. However, which, among other things, says that it will be in effect for anyone, anywhere, and so that's why we're having this conversation. It's a very, very strict data protection law focused on the rights of individuals and their personally identifying data.
Great. And who does GDPR affect?
Well, in our view and what we are advising our clients, GDPR affects pretty much anyone, again, anywhere in the world. It is focused on protecting the data of individuals with which one might be able to actually identify those individuals. But the flip side of that is it affects anyone who might acquire or store or otherwise use that personal data. So pretty much any business anywhere.
Right. So that slides right into you, Michael. So talk about Liquid Web and how the heck are you guys starting to wrestle with this whole GDPR monster?
It's definitely a word that we've used. It's a all-encompassing and very far-reaching rules and regulation. One of the things we've done with Liquid Web, we used to participate in what was called Safe Harbor. We've also done now is what's called Privacy Shield. And along with Privacy Shield and then using the DPAs that we have, the data protection addendums that we use with our client, allows them to know that as a processor for our clients, and our clients are basically considered the controller of the data. So we're considered the processor in this aspect to most of our clients in that regard. And so we have our privacy shield that we do there. So there's an arbitration involved. So there's there because in general, the EU does not list the US as having adequate data protection rules in place. So this whole privacy shield piece of it that we have allows us to say that we have the appropriate safeguards in place at Liquid Web, our physical security, our policies and procedures, our change management, our security operations and all that meet the requirements to ensure that the data is secured for our customers. And we take privacy very, our data and the privacy of the data here at Liquid Web for all of our customers very serious. So it's a new rule because it stretches a long ways for us, and it's adding a lot of complexity to our controller side for the data that we collect on people, such as our customers and their names and their emails and stuff like that. But from a general use for our clients, it hasn't caused us a whole lot of change, except we've added some additional languages into model contract clauses and our data protection addendums.
Great. So now when you talk about privacy shields, do you mean a specific collection of technologies that you have, or is this more sort of, if you will, marketing speak for the way that you guys treat and handle privacy of customer and client data?
Yeah, so what Privacy Shield is actually an organization. It's actually governed by the U.S. economics groups, And we end up doing it with them as with the Federal Trade Commission. It has sanctions to U.S. companies for not abiding. We actually have, there's attributors, so there's ways for, or arbitrators, I mean, there's ways for people, if they have a complaint, to file the complaint, no matter where they're at in the world, and that we're held legally by the U.S. government to maintain as well. So that's really what the Privacy Shield does, is it verifies that all of our policies, all of our procedures we do, all meet the realms. And we do that with a lot of our audits. We have service organizational compliance audit. We do our PCI and DSS, which is, the credit card industry's standards. And we also do, for the US side, is what we call HIPAA, which is the Health Insurance Portability acts. And so those are, it's kind of combining all that stuff together and showing that we meet all the rules and regulations that have to be in place for that.
Great. Now, Anne, back to you. I assume you're familiar with the privacy shields and what Michael was just talking about. Do you think that they adequately prepare a US-based company for GDPR?
Absolutely not. And, in fact, I'm really glad that Michael brought that up, and I wanted to follow on to say that, as he alluded, the US has been looked at up until now by pretty much the rest of the world as the least concerned about personal privacy and data privacy of any of the developed countries. And that's true if you look at, basically our federal law, for example, on email marketing, part of which I wrote, and pretty much any other aspect of data privacy in the US. We are just so far behind in terms of protecting individual privacy. And that is one of the reasons that companies now in the United States are just sort of, looking like deer in the headlights about, what do you mean we have to comply with GDPR and actually, care about individual data privacy? Because GDPR is a much, much stricter law than companies in the US have had to follow, up until now. And they also really don't want to give up their ability to suck as much data about, people on the internet as they can to analyze it. But GDPR really requires that they really tighten up the way they use and store and even acquire data.
Right. So let me jump in there and say one of the obvious questions is GDPR is coming from the European Union. So surely US companies don't have to worry about it. I mean, if we don't have an EU business arm, don't have to comply, or do we?
So, first of all, let me just say that I have read the full text of GDPR, which including the prefatory language is about 100 pages, many, many times, poring over the nuances of the law itself to understand exactly what the EU has done. And, monster was a really good term, and I think we are not the only ones to use it about GDPR. So part of the thing about GDPR is that it lays out a whole bunch of responsibilities. However, it is also extremely vague about certain aspects, and that is the reason that this is such a difficult thing for people to wrap their arms around. Who does it apply to, and both whom does it really protect and who really has to comply with it. As I mentioned, so there are two aspects to this, which taken together are why we advise companies and other organizations here in the US or really in any non-EU country that they really do need to comply with GDPR. One of those, as we've already discussed slightly, is that GDPR, unlike almost any other law I have ever seen, and I have a background in not only legislative drafting, but also legislative construction. So I have, crossed and glazed my eyes over a lot of laws. This is the only law I have ever seen that specifically states that they will go after anyone, anywhere in the world, EU or not, that compromises the data of an EU, well, I can't even say EU resident or citizen because that is the other area of ambiguity. Well, there are a lot of them, but specifically in this context, nowhere in this law does it actually define who they mean by the individuals that are protected. It doesn't say it's an EU citizen. It doesn't say it's an EU resident. It simply says someone who is, and I quote, in the union without ever defining what that means. And so here's the example that we give to non-EU organizations when we explain why we feel they need to comply. I could be, I'm a United States citizen and resident. I could go to your US based website, Dave, and I could purchase something using my US based mailing address and my US anchored email address. And so you would think, hey, no problem. There is no EU connection there. But I could be on a Lufthansa flight flying over Germany at the time that I am accessing your website. And technically, that would make me in the union in that moment. And because there is no requirement written within GDPR that says EU resident or citizen, it is very easy for me as a lawyer to see someone making that claim that me at that moment being in somewhere in the union space puts me in the union. Now, the third aspect of GDPR that ironically is one of the ones with great specificity is that it provides a private right of action. And what that means is individuals who believe that some organization has violated GDPR requirements with respect to that individual's data, under GDPR, they can bring an action against you. So it doesn't have to be an agency, it doesn't have to be the police, it doesn't have to be, some governing authority. An individual can bring an action against you under GDPR. So again, back to that example, now I am flying over Germany as I make that purchase on your US based website. And now something happens so that I believe you have somehow improperly used or stored my data. Under GDPR, I can bring an action against you. And if that sounds frightening, it should. And what we tell people is our job is to make sure you are not a test case. A lot of this ambiguity and vagueness is going to have to be clarified through lawsuits because the promulgating authority for GDPR has left all these sort of open to interpretation aspects that are really important aspects. So again, I think you said your website is Ask Dave Taylor. You really don't want some individual or an agency coming after you and you being the one that has to say, well, wait a minute, they weren't really in the EU, they were just on an airplane, or wait a minute, that person told me that they were not in the EU. So, you don't want to have to be the test case that is having to pay for that lawsuit.
Right. Well, there's questions about enforceability, though, because someone going after you and then that case being closed and then you having to pay a fine or something are entirely different things. But I want to switch back to you, Michael, and I'm curious. So Liquid Web keeps mailing lists and you have a newsletter you send out to your customers, correct?
Correct.
So how are you dealing with it as of May 25th? And how are you dealing with the older data that you have? Because presumably that also ends up being under the great um, nuclear fission cloud of GDPR.
Yeah. And we're at this point here, we're doing weekly meetings and discussing it, and we're looking at all aspects of where we've stored data, where we have data, making sure we're making changes to our processes to make sure there's an opt-in as required in GDPR now, and making sure that we have the ability to remove data that we don't have a use for anymore. And we're looking at all of our existing customers are going to have to opt back in, and if they don't, then we will not be communicating with them, and we'll have to get rid of that data. I know Ann will be talking about it in a bit. There's another part of it there that's called I got a right to be forgotten, which means if you contact me and say I want to be forgotten, then I have to make all reasonable aspects to get rid of that data unless there's some kind of requirement for me to keep it that is arguable in the law side. And reality of it is that's even up for debate at this point. So we're doing a lot on our side, and we're looking at everybody we use and who we have store or help process any of our personal data that we collect on people, including their website, and doing our opt-in. We're updating their privacy policies again. And even though they were updated back in September and we've done some reviews, we're finding out some more things that we want to clarify up. But the big thing is that no longer just a automatic click that you opt in when you purchase something from me or contact me via my website. There is an acknowledgement that says, you know, you click by clicking here, you are opting in for these services, and we may do this with your data, making it very clear so we can show that we've appropriately informed clearly to the person talking to us or contacting us that what we're going to do with their data or communicate with them.
Right. Now, Anne, am I correct?
Can I just
Yeah.
quickly follow on to that? First of all, I think Liquid Web is doing a brilliant job to be having everyone opt back in, et cetera. Having, again, reviewed GDPR way more than a sane person would, you know, what I can say, because I heard you specifically ask also about previously collected data. In other words, for example, with a mailing list, email addresses that, you know, are acquired prior to May 25th. And in, you know, my reading at least, you know, and again, as a lawyer with a background in legislative construction, my reading of GDPR basically breaks down how you have to treat previously acquired data into two different scenarios. In my opinion, data that has been acquired prior to May 25th, you don't have to, but it's a good idea, like Liquid Web is doing, just, you know, for a whole host of reasons, not all of which have to do with GDPR. But in my opinion, you do not have to reconfirm and get new consent for data that was acquired prior to May 25th. So that's one piece. That's the consent piece of GDPR. However, there are many forward-looking provisions of GDPR that you do have to still apply even on previously acquired data, you know, such as Michael brought up very rightly, the right to be forgotten. Another one is that there is a requirement in GDPR that if you suffer a breach, that you have to let the supervising authorities know within 72 hours. And that would be true also for data that's acquired previous to May 25th. In other words, you know, the prospective aspects of GDPR, the forward-looking aspects, how you store data, how you handle data, what happens if you have a data breach, if you're passing that data onto a processor, all of those things which are forward-looking also apply to data that you acquired previously, you know, previous to May 25th. However, requirements that apply at the moment of data acquisition, those, you know, by definition, can't be retrospective. And again, you know, you, in my opinion, having read GDPR, you cannot be, you know, have an action filed against you saying, well, you didn't acquire consent back in 2017 because now GDPR requires you get consent. Because frankly, here in the United States, for example, we have a constitutional prohibition against what are called ex post facto laws. You can't pass a law which makes previous actions illegal and then prosecute based on, you know, that law. So, you know, that's a long way of saying good on you, Liquid Web, for reconfirming people, because it's always a good idea to have actual opt-in. But in my view, data that you acquired before May 25th, you know, you don't have to be worried about the at the moment aspects such as consent. You just need to worry about pretty much everything else, which is still a lot.
Right. So a question that ties into that is, isn't it the case that data expires, that you can't just keep archival customer data even if they opt in, but you still can't keep it forever?
Are you asking me that?
I am asking you
Yeah,
that,
for
Anne.
me. Okay. Yeah. Well, it really depends on the type of data. You know, again, here in the US and pretty much anywhere else, consent, previous consent does not expire, but a lot of other data can, especially when you start dealing again with other data regulations, such as Michael mentioned HIPAA and those sorts of things. And I am not, frankly, qualified to discuss what types of data, expire, because that's not my area. But I do know that there are types of data that expire, and I'm guessing Michael or liquid web lawyers might know that better than I. Consent, not so much. That said, there is this sort of very gray area that we have decided is not so gray, which is, let's say, for example, I run a mailing list, and Dave, I have your email address on it. I acquired it in 2017. And then, so again, in our view, we do not have to reach out to you and ask you to reconfirm, because in fact, if everyone had to do that, you would suddenly be getting spammed with a ton of reconfirmations, and that in itself is an issue. However, if you then come back and give me your email address again for any reason, then that triggers the new GDPR requirements. In other words, we may already have certain pieces of data from you, but if you give them to us again, then that triggers the GDPR requirement, and so you need to get the consent. And at that point, if you don't get the consent, you would need to basically cancel the previous consent that you had. Did that make sense?
Yeah. Now, again, back to you, Michael. So you're re-opting everyone in. What if you have a customer who's a current paying customer and they don't re-opt in, but you have important communication you need to share with them about the status of servers or about some upgrades or something? What's your expectation of how you'll then be able to communicate with your customers?
Well, at that point, we're going to go with what so we were just talking about, the fact that it was acquired prior to the May 25th. So obviously, we're going to communicate with our customers as we need to in that aspect. But our new customers, they're going to have to opt in, or we won't have a means to be able to communicate with them. And at that point, it may not make sense to have them, as a customer, and that's a sad state for us to an extent. But we got to protect ourselves as well. So, I mean, we're trying to reaffirm everybody into that we're taking it very serious, and we're doing the GDPR stuff and trying to get them to re-opt back in. One, it also makes sure we have the most up-to-date data from them. And those that don't, and as long as they were acquired before May 25th, we'll still communicate with our customers in that aspect.
Great. Okay. So, Anne, let's get back to one of the really, really big definitions in GDPR, and that's the difference between a data controller and a data processor. So can you give us a sense of which is which? And then I don't want you to tell me, I want Michael to tell me what he thinks Liquid Web is. And then I want to go back to you, Anne, and have you tell us from a legal perspective which of those two categories Liquid Web actually falls into. So, Anne, you start with data controller versus data processor.
I will. However, I am first going to very quickly mention, because I'm sure people listening to this, some may be wondering in terms of, the liquid web issue of what if you don't get consent from a new customer, then you can't communicate with them, et cetera. And there will be people out there listening saying, yeah, but what about the legitimate interest clause of GDPR? There is another aspect of GDPR which provides that even without, direct explicit consent, if there is a legitimate interest, you may be able to communicate with someone anyway. And what I would say to that is the legitimate interest aspect is one of the most highly confused, contested, etc. things out there. So I would never actually recommend anyone invoke it. So again, my hat is off to Liquid Web for really doing this right and just saying, look, if you're not going to give us permission to communicate with you, then how the heck can we have a customer provider relationship? And so, but I just wanted to put that out there. Don't ever rely on the legitimate interest aspect of GDPR, although a lot of non-union organizations are expecting to do that. And I think it's a very bad way to go, because there's no real way to prove it, because it's not a defined term. As far as controller and processor goes, basically the sort of rule of thumb is, if you are the primary organization that acquired the data, in other words, the individual gave you that data, or you otherwise are acquiring that data directly from the individual, and let me say here that if they're not giving it to you, you shouldn't be acquiring it, then you are the controller. In other words, it is the organization or party of first instance. A data processor is any organization that is being passed an individual's data from a data, well, either a data controller or another processor. So, for example, if you are uploading your list of email addresses to your email service provider, your ESP, then, and you are the one that acquired those email addresses. You are the data controller. You control what happens to that data. And your email service provider is the data processor. Now, an organization can be both a data controller and a data processor. And an ESP, again, an email service provider, is a great example because email service providers often provide their customers with widgets that can go on the customer's website so people can sign up and provide their email address. But that email address in that widget, when it's entered, is going directly to the email service provider. So I would argue in that instance that the email service provider is actually the data controller because they are the ones that are acquiring it in the first interest. Make
All right.
sense?
Yep. And Michael, what are you?
We are both. We are basically, I look at it as we're a processor. For most of our customers, that's what we are. But because we actually obtain their email address and their contact information, that we are a controller in that aspect of the data. So for the customers that are using our service here and they have their data on our servers that they've leased from us, whether it's our cloud-based or a dedicated server, we're a processor for them in that aspect, but we're also a controller of their data that they provided to us to do business with them or to market to them. So that's where we fall on the lines of being both.
Great. Okay. And do you agree?
I absolutely agree, and I think this might be an opportunity for me to give a plug for Liquid Web in case anyone listening to this isn't already a customer. We are actually customers of Liquid Web, and they do an absolutely brilliant, fantastic job. And now that I say that, I should also add that they did not reach out to me to do this podcast with them. I actually personally reached out to them and offered myself because, again, I think they are just awesome.
So does that make you a controller or a processor?
Haha. Although actually in our business, we are a controller.
Fair enough. Now, I want to go back and also talk about the right to be forgotten. Now, this is something that has been sort of hovering on the edges for a couple of years now. And obviously the really big data collection companies like Google and Facebook have been facing this. How is the right to be forgotten clause in GDPR going to change the way people will have to do business if they have, for example, an email newsletter?
Is that for me?
Yeah, take your questions.
So I would say really the main way it's going to change things, well, first of all, I would say it shouldn't. It shouldn't be changing anything at all because if someone contacts you and says, I want you to remove all my data, you just ought to do it. You shouldn't be playing sort of hide the ball with that data because you think that you don't have to under the law. However, the primary technical way that it is going to change things is that the GDPR version ties into also their right to access the data. In other words, under a strict interpretation of GDPR, if you are taking and storing someone's data, you have to also give them the ability to access the data that you have stored. So that is an added twist that is honestly probably one of the more problematic aspects of GDPR from a technical standpoint, because you can have a company here in the US or anywhere that is extremely good about removing the data when it's requested, and that is the right to be forgotten or the right for erasure, as it's also called. But then to also add that layer of, oh gosh, now we have to give, John Doe a way to access that data. And for some organizations, that's not so problematic because they have dashboards their customers can log into and all that sort of thing. But for other organizations, particularly maybe smaller ones, that again, on a strict interpretation is fairly problematic. Here in the United States, again, because I come from the email world, I have lots of email analogies or examples. Here in the United States, when someone opts out of your mailing list, you are required to remove their email address and associated data within 10 days, which is ridiculous because it should be within 24 hours. But again, the US has always had the laxest privacy laws. And so a lot of the aspect of the right to be forgotten in non-EU countries, and particularly in the US, are going to deal with those sorts of issues. Again, the right to be forgotten being implemented much more quickly because it's not reasonable to take 10 days in the world view, even though the US view it is. And then again, the ability to actually access the personal data that you have stored about a given individual.
Uh,
So, yeah, go,
I was
Michael.
gonna say, a little bit from a liquid web standpoint, we took this under a phase of data flow, and that's where I think where a lot of the big companies have got to look at this, or even the small companies. It's like understanding the information you have, understanding how it flows, describing that information and how it flows through your different things. And the biggest thing is identifying its key elements. What kind of data does it have? Why are we processing it? Why do we need it? And once you can identify that stuff, it can help you get a grasp onto what you're doing with it. And I think that's one of the things that we recommend to any of our customers when they ask us a little bit about GDPR. We said, we're not the experts in it. We help you obtain GDPR compliance and we do our parts, but there's a lot of things you need to do on your side of it, and that's where we get into that part of it. So it's a lot of describing what your processes are and making sure you know where your data is and why you have it.
Great.
I think Michael also raises an extremely uh, relevant point that again, companies in the US are used to being able to just drink from that fire hose of data and collect data that they don't really need, that they never really identified as needing, but now they have it. What are they going to do with it? And so to start looking at what data do we actually need rather than, hey, what can we get? That's super important and something that companies in the US have never really ever had to think about before, which is much more telling about the US than it is about this EU law.
So I file a right to be forgotten request, whether it takes 24 hours or 10 days or whatever. But even if you are as enthusiastic as you can be, what about backup tapes? Michael, how are you guys looking at the privacy and GDPR implications of backups and potential restores after system failures?
That's a big technical one for us, and we've been really looking at all that aspects of it because there is a chance we're going to have backups, so we have to keep track of how our backup life cycle is going and what we've done. So what we're doing is we're trying to keep a basic list of if we delete somebody who's asked to be forgotten, this is our process of looking at it. We need to make sure that if we do a restore that we make sure that data is gone, because a lot of times with a backup I can't just go into that backup legitimately right now. So it's all about having a plan from our perspective from GDPR and making sure we have the right plan in place to be able to handle those. So we're looking at it as that, we know what our backup life cycle is. So we know that, we could, if we restore back to a certain time, then we have to recheck to make sure we've done that forgotten pieces for those that wanted to be removed out.
Right. So, Anne, from the legal perspective, what is the deal with things like having backup archives and offsite backup hard drives and similar?
Well, this is definitely one of those areas that is almost certainly going to be litigated because not only does it not really specifically spell everything out in that law, but just also because what's reasonable and, somewhere someone is going to forget about an archived backup and it's going to get breached and leaked and, those sorts of things happen. And so, what I would say and, you know, this is a discussion that we're having in order to facilitate and assist organizations with getting prepared for GDPR. And what I would say is, yes, they are covered under GDPR. The more attenuated something gets, the less likely you are to become that test case. And so, you know, use common sense, which of course is often anything but common. But, you know, if, you know, do your very best efforts to make sure that it is, you know, erased everywhere, and then move on. I would say one of the most important aspects of that sort of thing is something that, you know, we have been talking about, you know, since way before GDPR came into being, and that is organizations absolutely must have a written document retention policy. And in this case, also a written data retention policy. And as long as you have that policy written out and it is followed religiously, then that gets you a large part of the way there to being covered, because you are spelling out the steps that have to be taken for the data or the documents to be retained. And also that means you're also spelling out deletion policies. And so, you know, again, any organization should have that anyway. I have actually seen, I've seen one lawsuit where the defending organization ended up being put out of business and acquired by the plaintiff organization, because when the plaintiff organization demanded the production of certain documents, the defending organization was not able to produce those documents because, oh, they were deleted, but other documents of the same type had not been deleted, and they did not have any policy they could point to that explained the item deletion. So, you know, again, they should, all organizations should already be having these policies written out and followed. And so going to the data, you know, the backups, if it says right in there, this backup and this backup shall also be deleted upon a request for erasure, or even just because we have that, you know, written as a schedule of when that stuff gets deleted. As long as you're doing all of that, you're fairly well covered.
Great. So, Michael, can you talk a little bit about your perspective on if customers are also doing cloud backups, not necessarily to Liquid Web, but to maybe Dropbox or Google or Apple's cloud services? And if they're duplicating their data, do you feel you have a responsibility to let them know that that might be dangerous?
Yeah, I mean, we under GDPR, it a lot of the things that are out there that are bad, it says, you know, it's our responsibility to let you know if things that you're doing aren't compliant, or are compliant, I should say. And in this case here, we would inform them that they need to make sure that if they're, especially if they have a DPA with us and they're listed as a European company, we're going to indicate to them they need to make sure they have the right stuff in place. So any place we would do stuff with, we're going to have a DPA with them from that aspect of it. They may be a sub-processor of ours, but the companies really do need to take that into consideration. That's why I recommend they talk to legal experts in the GDPR to find out what parts they need to be more concerned about. And it's what we do as well. And we've talked with our auditors on it. And, you know, it's definitely something I think that the customer needs to be concerned on. I just need to let them know that, hey, keep in mind that this would need to be covered as well for as part of your compliance, but it's not something we can control for you.
Right. So, that makes sense. Now, do you anticipate that you'll lose any of your customers as this all shakes out over the next 30 days?
Yeah, there's always a risk to it, but I think we've done enough pieces into play that we can help the clients. I mean, part of our clients, we're going to lose the ones that want us to make them 100% compliant, and I can't do that because you as a controller have a lot of obligations that you have to follow as well. So I can only help obtain from being a legitimate processor for you to use, but there's going to be customers that are looking for somebody that can provide it all, and that is not something we do. We can make recommendations of places you can contact for getting assistance in GDPR.
Makes sense. So now back to you, Anne. I want to reinforce a point that I think we've hit a couple of times, but it's really important. So I want to clarify that if I have a company and none of my employees, and frankly, none of my customers are in the EU, do I still have to worry about GDPR, or is this really only for global or international firms?
You absolutely do still have to worry about it because, again, that scenario where I'm flying over Germany, that happens. Not only that, but a lot of organizations had initially thought, for example, US-based organizations had initially thought, well, I can simply reject any traffic or customers from people, in the EU. And in fact, there are still a lot of companies that are saying that, and that is extremely misguided. For one thing, how are they going to determine whether someone is hitting their site or their company from the EU? Well, they say we're going to geolocate their IP address. We're going to when at the moment that they connect to our site, we're going to look, grab their IP address and determine where it is. Well, first of all, geolocation is very imprecise. And so to give you a great example, I live in Boulder, Colorado, but systems often think I'm coming in from Dallas, Texas, which just isn't true, right? It's very imprecise. Secondly, there's this little thing called VPNs, which lots of people use. So if I were on a VPN, you might think I was in Sweden or almost anywhere, even though I am sitting here in Boulder. And the same would be true for someone in the EU using a VPN. But thirdly, GDPR also very specifically prohibits what they call profiling, which is the automated determination of a given individual indicator. In other words, you using some method of in an automated fashion, checking to determine a person's name or a person's identity, or specifically spelled out in GDPR, a person's online identifier. So, a strict reading of GDPR says you are not even allowed to use an automated means to determine someone's location. So, you just really can't know. And then finally, again, that private right of action is such that, individuals are going to be looking, just itching to nail someone under GDPR. And, we believe that organizations in the US are going to be prime targets because everyone else in the world over knows that the US has the laxest laws, that organizations in the US are the ones who play the most, fast and loose with individual data. So they're going to be looking to nail us.
Okay. So vaguely depressing. We'll come back to that in a second. So as someone who's an online publisher, obviously, I have a lot of these things I have to wrestle with, like it or not. But how do I, as an online business, make sure that organizations and services that are dealing with my data, like my email list provider, how do I make sure they're GDPR compliant and aren't going to end up getting me in trouble simply because I'm using them, assuming that they're GDPR compliant, but they are thinking, whatever, we don't have to worry about it?
Is that for me or Michael?
Let's start with you, Anne.
As the individual, so let me say this about that. We have counseled, again, primarily US-based businesses to, they're saying we don't want to get compliant, it's such a hassle, this and that, but we have also had people asking us basically what I think you're asking, which is how do you know if someone, an organization is in fact GDPR compliant? And so the flip side of that is we're telling these companies, you know what? People are looking for that. So it's a marketing bonus if you can put on your website, hey, we are GDPR compliant. So I would say look for that, although there isn't a certifying authority, so there's not going to be a seal of approval. But if a company says we're GDPR compliant, First of all, that means they're aware of GDPR, which a lot of companies still aren't. And second of all, it means presumably, if they're a legitimate company, that they have taken the steps to become compliant. Even if they're not fully compliant simply because of the vagaries of the law, it means they are more likely to be really treating your private personal data with the respect that GDPR requires. Other than that, ask them. That's really the only way you can know. And, say, hey, are you compliant with GDPR? And if they're not, you know, and that's what you're looking for, then, go find another organization. I would also say pretty much if any organization at this point takes your email address and puts you on a mailing list without actually asking you and expecting that you can just opt out if you don't want our email, they're not GDPR compliant. So that's a pretty easy test given that most organizations now collect email addresses. I also, there's one other aspect of GDPR that we haven't raised that doesn't have anything to do with this, but I feel is extremely important. So may I?
Actually, hold on just for a second, because
Okay.
I want to just bounce over to Michael and ask, how are you going to convey to existing and especially future customers how much work you have done to be GDPR compliant?
We're putting up a new page directly, and it's going to be explicitly about GDPR. A lot of really frequently asked questions, and indicating where our DPAs are, how we're meeting the compliance, you know, and links back to different things that we've had done by auditors and verifying our stuff. But also just to even piggyback is what you were just talking about on, who we do business with, because obviously Liquid Web does business a lot. And a lot of places I look at is looking at your terms of services agreements that you have with them and making sure that you have the right things in place, that they're handling privacy of your data and what they're going to do with it. So you know who you're giving your data to is abiding by the rules that you believe you want them to. And I think so you just got to do due diligence with each of your vendors that you work with. And so that's part of the part that I look at in that aspect of reassurance is if they're not willing to answer some of your questions, and probably aren't going to want to use them. Are they willing to agree to terms of service and privacy rules?
You know what? That actually is exactly roughly the thing that I wanted to bring up. So can I jump in here?
Please.
Please. Again, Michael is spot on about having to review your agreements with your vendors. But beyond that, GDPR specifically requires that any processor that you are passing data to, you must have a contract in place with them, and they must be GDPR compliant. The part that we are trying to highlight is that not only must you review all your contracts, and by contract we mean actual contracts, not just what they tell you on their website. Now, it's possible that depending on how they're written, a terms of service, a TOS, or an AUP, acceptable user policy, might qualify as a binding contract if you also had to do something, and that goes into contract law, which we're not going to talk about here. But GDPR requires actual, specific contracts between a controller and a processor, and that the processor, any processor the controller passes data to, it's, the burden is on the controller to make sure that that processor is GDPR compliant and states so in their contract. But the part that no one else that I've seen or heard anywhere is talking about is this: we are advising anyone who is a data controller in any way to put into the contracts between them and their data processors, and the processors are going to, balk at this, but to protect yourselves, GDPR specifically says that if a controller passes data to a processor and that processor is not actually GDPR compliant, and the processor experiences a problem such as a breach, such that the data that the controller gave to them is put at risk, that the controller is on the hook up to 100% for the fines that come out of that data being compromised. In other words, Liquid Web hands us data. We are the data processor. Now we experience a breach and the data Liquid Web gave to us is compromised. Liquid Web can be on the hook for those penalties, which are stiff. The GDPR debt penalties are, it's in EU dollar or euros, of course, but it amounts to 2 million up to $4 million per incident, or 2 to 4% of your entire company's revenue for the year. I mean, it's a very, very high penalty. So we are advising controllers to make sure their contracts with their processors include an indemnification clause that says something to the effect of, if this processor has a breach involving the controller's data, and if because of that the controller ends up having to appear in court or is fined under GDPR, that processor will indemnify the controller for that issue, because it was the controller's either lack security or whatever that led to the breach. Now that's something that we can actually help with in terms of writing the language for that in a contract, and we're happy to do that because we feel very strongly about that.
Well, a suitably, I don't know, bucket of cold water way to end. I have to say that there is a sense that this is sort of like the EU somehow managing to define global internet law, which is an interesting thing because no other country seems to be able to pull this off. So it's going to be really interesting to watch how this plays out over the next year or two. But certainly, I think the companies that do nothing and just ignore it are going to be much more at risk than the companies that are at least trying and at least have documented some process that they're trying to, match at least what they understand of GDPR, because it's also clear that there's a huge amount of ambiguity and that there's a lot that needs to be clarified in a variety of different areas. So,
and it will be done by lawsuits.
Yeah, unfortunately. And so what I'd like to do as we wrap up is I'd like to just sort of invite each of you to give me just maybe a couple of closing thoughts about this whole big topic. So Michael, just give us just a sentence or two of, are you optimistic or pessimistic? Do you think this is good? So just wrap us up here.
I'm optimistic that we're doing the right things to get in there. I'm concerned about any of the lawsuits, and my goal is I don't want to be a test case from Liquid Web. I don't want to be putting up my company, my bosses to have to answer to any of that stuff there. So we're taking it very serious, and I really recommend that people really learn about the ins and outs as much as they can about it.
And Anne, how about you? Closing thoughts.
Okay, well, my first closing thought, because it was something I wanted to say earlier when Michael had said something about customers or potential customers who expect, Liquid Web, as an example, to do all their GDPR compliance for them, and might they lose customers if they can't do that, which of course they can't, because a lot of it's up to the customer. What we're actually seeing is more that service organizations are losing customers or potential customers because the service organization is requiring their customer to be GDPR compliant. In other words, the potential customer is saying, well, if you're going to make us actually confirm consent, forget it. We're not going to be your customer. And you know what? Good riddance, because you don't want those customers, because they put you at risk. The only other thing I would say is GDPR is huge. It's vague, it's complicated, but if you take it a bit at a time and really just start working on it, it's doable. We are seeing actually that companies who are already following industry best practices usually are at least 70% of the way to being fully compliant with GDPR anyway. So even though it looks like the sky is falling, if you sort of just take it one step at a time, it's doable. And I'd also like to say that most of the topics that we have covered here in this podcast, we have plain English, for the average person articles written about on our blog about most of these, and you can get to our blog from isipp.com, and I'm pretty sure that that's going to also be up on some screen or in the Liquid Web newsletter. But it's absolutely, there's no charge to access these articles. We don't even ask you for your email address, like, in order to get to them. So yeah, a lot of this, including the aspect of having an indemnification clause and sort of more esoteric things, we have articles about all of those up there.
Really terrific. Now, you've been listening to Michael Ashton, Senior Director of Platform, and Ann Mitchell, Attorney at Law, discuss the General Data Protection Regulation, privacy regulation, whoops, and how it's going to impact everything online. I'm Dave Taylor, and you can check out my tech blog at askdavetaylor.com. Thanks for joining us for this conversation.